go deeper into this with Mark Zaid. He's an attorney who specializes in cases involving national security and security clearances. Mark, thanks for being here. I want to put a little meat on those bones that Sadie started to give us. Explain to me what the difference is between what we might see in that affidavit, meaning the whole reasoning behind this this search warrant and what they were looking for, versus what some people accuse the FBI of doing, and that was being on a fishing expedition. Well,
the affidavit that provides the supporting information would give a template as to what they were basing it on. You know, did they have an informant? Wouldn't necessarily indicate the identity, obviously, of the informant, but it would give details to allow the magistrate judge to understand that there was probable cause that a crime or crimes were committed. And it is not typical that an affidavit of this type would be released at this early stage. Later on, I've handled Freedom of Information Act cases involving Espionage Act prosecutions. We've gotten copies of those supporting affidavits, but years after the prosecution ended.
Let's talk about the levels of classification. I was just talking to Sadie about that. There were different things in there, and the warrant specifically asked for different things in here. What do they mean? For our purposes, whether something is top secret or classified or compartmented, are these distinctions relevant to us, or is it all bad?
No, they are important distinctions. Now, the first thing to understand is under the Espionage Act, which is one of the statutes that could be at play, that act goes back over a century. It talks about national defense information because it was written before we have the current classification status and framework. Now, that means actually the information doesn't even have to be classified, although I do not know of any recent prosecutions under the act where the information was not, and I dare say I can't imagine the Justice Department would go after the president for unclassified information under the Espionage Act. But the executive order that sets forth different levels of classification, confidential, secret, top secret, then SCI, which you mentioned, is sort of, if you think of an offshoot of one of TS, could also be under secret, or a SAP, which is special access programs. Those pertain to the levels of harm, by definition, that would be caused to the United States if that information were released, whether to a foreign power or to the media or never, just retained in a location where others who are unauthorized might have access to it.
You tweeted about 10 minutes ago that Donald Trump, via Breitbart, released unredacted copies of property receipts containing the names of FBI agents. Based on his history, this can only be interpreted as an intention to cause these special agents, one of whom I know, and their families grief and subject them to possible threats. Now, obviously, we're not putting that up. Do you think that was? Do you think that's deliberate, or do you think they got the thing and they published it?
Look, he didn't have a requirement to redact the information. But when I file papers that have email addresses and identifying information of agents in my court cases, I know it's best in today's world, unfortunately, to redact that information out. There is no need for the public to know the identities of the FBI agents. If the lawyers for Trump want to make an issue of these agents, hey, that's fair game. Go right ahead, knock yourself out. But by putting this out there, just like we saw in the attack on the FBI's field office in Cincinnati, just like I saw with death threats against me, where individuals were prosecuted, all because of Donald Trump and folks like Rush Limbaugh and other Fox News TV commentators who mentioned my name in conjunction with the cases I've handled against the administration, that brings about consequences. And those are not good consequences.
You wrote on Twitter as well, and this is interesting, that anybody inside the Secret Service who knew that classified documents were being stored at Mar-a-Lago would have had a duty to report it up the chain. Their loyalty is to the government, not to a president or a former president. Do you have any idea whether that's where this information came from? We don't know who the informant is at the moment, or whether there are multiple informants, or where the government got their information from.
No, we don't. We of course do not know that, just as Sadie mentioned. And there's a number of questions that need to be looked at for this investigation that go well beyond just Donald Trump. Who packed the materials at the White House to ship them down to Mar-a-Lago? Who knew about the documents being present at Mar-a-Lago? how many former White House officials or individuals who held or maybe still hold in some capacity a security clearance were aware that these documents were at Mar-a-Lago? Once the documents were retrieved a few months ago by the National Archives and the FBI, who was aware that there still were documents that are classified, marked classified, still at Mar-a-Lago? The issue with the Secret Service is a complicated one because historically, and I've represented many Secret Service agents and officers, these are some of the most distinguished law enforcement personnel that work for the federal government. The Secret Service primarily always imparts upon their membership, never ever reveal anything about a protectee. But we learned during the Clinton, Lewinsky, Judge Starr independent counsel investigation that there is no privilege of protecting the protectee, that these agents and officers, in this case, agents who are on the protective detail for the former president, are law enforcement officers. And if they were aware of classified information being held at Mar-a-Lago at any time, they had a duty to report that up their management chain. Now, maybe they did if they knew, and that's a very interesting question that the Inspector Generals at Department of Homeland Security and Justice might want to look into to see.
You mentioned the Espionage Act. We have had people prosecuted under the Espionage Act in recent years. Chelsea Manning, reality winner. Is there some reason to believe that Donald Trump is insulated from the same kinds of charges that those individuals have faced?
There are some defenses, without a doubt, that Trump and his lawyers will raise, primarily because the statutes in question were never intended or envisioned to be operable against the president of the United States. So sometimes there are references to executive branch employees or officers, and the debate will be, does that include the president of the United States? Now, cases like Chelsea Manning, whose book I actually helped go through pre-publication review recently so that it was properly reviewed, or reality winner, cases where individuals obtained classified information illegally and released it illegally are different than what this case might be. And it's important to understand there doesn't have to be any intent or allegation that the president or those around him were going to sell the information or leak it to the right-wing media, left-wing media, who cares, or a foreign power. Possession of that information in a location where they are not authorized to have it is just as sufficient. And just 3 years ago, a former NSA contractor was sentenced to 9 years in prison for having a hoard of classified documents in his home that, as far as I understand, was never intended to ever leave that residence.